Test Prep Pundits, a synonym for success, and a home to top 1% scores. Congratulations to Gutha Mandala for achieving SAT score 1570, Farah Khalil 1540, Kunal Varma 1510, and many more top 1% scores.
Join our summer premiere SAT and ACT program. Pay now. Start in summer and get 40% discount.
Contact us, info@testpreppundits.com, or call us 844-383-7844. Visit us, www.testpreppundits.com.
మలబార్ గోల్డ్ అండ్ డైమండ్స్ వారి గోల్డ్ ప్రామిస్ తో కురుస్తోంది బంగారు నాణాల వర్షం. గోల్డ్ అండ్ డైమండ్ ఆభరణాలు కొనుగోలు చేసి బంగారు నాణాలని ఉచితంగా తప్పకుండా పొందండి. త్వరపడండి, మీ దగ్గరలోని స్టోర్ కి వెళ్లి ప్రత్యేకమైన జ్యువెలరీ కలెక్షన్ ని ప్రత్యేకమైన ధరల్లో పొందండి. కేవలం మలబార్ గోల్డ్ అండ్ డైమండ్స్ తో మాత్రమే.
మలబార్ గోల్డ్ అండ్ డైమండ్స్.
Hire international teachers who are well trained in U.S. curriculum for just $20 an hour. Or for 2 students group, $15 an hour. We teach math, science, and English for elementary, middle, and high school. Contact info@testpreppundits. Call at 844-383-7844.
PSAT. Do you have a middle school child? Are you aiming for top Ivy League colleges? Do you know how strong they are in academics? We have an innovative PSAT program for grades 6 through 9. We will help your child thrive in academics and get them to the top 1% of the nation. It's never too early to start. Join our prestigious PSAT program. For more information, contact us. info@testpreppundits.com or 844-383-7844.
Summer is the best time to boost your scores. Test Prep Pundits present Self-Prep SAT ACT course for just $199. Stellar digital curriculum expert videos for every question. 15 full-length tests. Contact info@testpreppundits. Call at 844-383-7844.
ఆకర్షణీయమైన చీరలు, అప్పురపరిచే ధరలు. అందరికీ నచ్చిన, అందరూ మెచ్చిన షో మన లక్కీ మహిళ. బోలెడంత ఎక్సైట్మెంట్, వండర్ఫుల్ విన్నింగ్ మూమెంట్స్.
ఎగ్జాక్ట్ చెప్పారు, మీరే గెలుచుకున్నారండి. కంగ్రాచులేషన్స్, $220.
సెలబ్రిటీ హోస్టులు, అదిరిపోయే పంచులు, సరదా సరదా కబుర్లు.
ఆశ దోశ అప్పడం బడ హెల్ప్ మీరు ఆడుతున్నారు.
ఇలా మరెన్నో మెమరబుల్ మూమెంట్స్ తోటి ఫస్ట్ యానివర్సరీ జరుపుకుంటోంది మన లక్కీ మహిళ. Watch it live only on TV Asia Telugu.
Test Prep Pundits, a synonym for success, and a home to top 1% scores. Congratulations to Gutha Mandala for achieving SAT score 1570, Farah Khalil 1540, Kunal Varma 1510, and many more top 1% scores.
Join our summer premiere SAT and ACT program. Pay now. Start in summer and get 40% discount.
Contact us, info@testpreppundits.com, or call us 844-383-7844. Visit us, www.testpreppundits.com.
మలబార్ గోల్డ్ అండ్ డైమండ్స్ వారి గోల్డ్ ప్రామిస్ తో కురుస్తోంది బంగారు నాణాల వర్షం. గోల్డ్ అండ్ డైమండ్ ఆభరణాలు కొనుగోలు చేసి బంగారు నాణాలని ఉచితంగా తప్పకుండా పొందండి. త్వరపడండి, మీ దగ్గరలోని స్టోర్ కి వెళ్లి ప్రత్యేకమైన జ్యువెలరీ కలెక్షన్ ని ప్రత్యేకమైన ధరల్లో పొందండి. కేవలం మలబార్ గోల్డ్ అండ్ డైమండ్స్ తో మాత్రమే.
మలబార్ గోల్డ్ అండ్ డైమండ్స్.
Hire international teachers who are well trained in U.S. curriculum for just $20 an hour. Or for 2 students group, $15 an hour. We teach math, science, and English for elementary, middle, and high school. Contact info@testpreppundits. Call at 844-383-7844.
PSAT. Do you have a middle school child? Are you aiming for top Ivy League colleges? Do you know how strong they are in academics? We have an innovative PSAT program for grades 6 through 9. We will help your child thrive in academics and get them to the top 1% of the nation. It's never too early to start. Join our prestigious PSAT program. For more information, contact us. info@testpreppundits.com or 844-383-7844.
ప్రేక్షకులందరికీ హలో అండ్ వెల్కమ్ అండి టు yet another fabulous episode of our talk show with experts. మనతో ఉన్నారు ఇవాళటి ఎక్స్పర్ట్ రెబెకా చెన్. రెబెకా, hi and welcome to the show.
Thank you for having me.
Rebecca Chen is also an attorney with the RNN law group anamata. Ee roju Rahul garu and Emily garu iddaru leru, so Rebecca garu is filling in for them. So thank you for being on the show today, Andy. This program has been brought to you by the Test Prep Pundits, a home to the top 1% scores. They're conducting a free SAT and ACT boot camp. This is on July 6th. So please check their website, www.testpreppundits.com, for further details. The program has been supported by Malabar Jewelers and Movers.com. Watch us on Yup TV, Facebook, YouTube, Sling TV, World BBTV, and Dish Network. All right. Awesome. We're recording in progress. All right. On to the topic for today. Why are priority dates backlogged only for Indians? Rebecca, I know this is a problem that we've been having for a long time now. So we just wanted to sort of get your take on why is it that, India is the only country that's still backlogged. Is it going to change? Is it not? What can we expect, or what can we do to remediate the situation if we can?
Right. Yeah. So anyone looking at the employment-based chart of the visa bulletin can see a very vast difference between India and every other country in the world. So for every other country, for the EB2 and EB3 categories, it shows as current. The only other country that has a backlog right now is mainland China, but they also are about 5 or 6 years ahead of where India is in terms of the priority dates right now. India is the most severely backlogged in the employment-based EB2 and 3 categories. And the main culprit for this is really the 7% country cap, which is kind of this archaic feature of the immigration system from decades ago that when Congress was coming up with the immigration system as we know it now, they decided for whatever reason that the number of green cards that could be issued each year, out of those green cards, there should be a 7% cap on the number of recipients from each country in the world, regardless of population size of each country, regardless of the demand for green cards from each country or the eligibility of the applicants from those countries. The most that could be allocated to nationals of each country was 7%. And I believe the thinking at the time was along the lines of equity, as in, making the immigration system more available to nationals of different countries. That's also a bit of the reasoning behind the diversity visa. But, this 7% country cap was put in place, like I said, decades ago, and it clearly is not really, useful or meeting the current situation. It's created this situation where there is enormous demand for green cards from India in particular. And that demand is, we have to remember for the EB2 and EB3 categories, because those are categories that require a U.S. employer sponsor, that demand is from U.S. businesses. These are businesses that have gone through the process of the PERM labor certification. They have already tested the job market and made the government has made the determination that there is not a qualified U.S. worker to fill this U.S. business's job opening. And they have determined also that the applicant that the company is sponsoring is qualified. So they've already gone through those processes to have an I-140 approval in the EB2 or 3 categories. Right. And to then put, a cap on how many applicants from each of those countries can be issued their green cards when there is that significant demand from U.S. businesses just doesn't really make sense right now in our, in the, modern world. So it has led to this really disproportionate situation where your number of years of wait for a green card just depends on where you were born, your country of birth. If you happened to have, if your parents were by chance traveling at the time you were born and you happened to be born somewhere other than India, your wait for a green card is decades different in the wait for a green card, which, how does that, meet the goal of equity or fairness, if that's what Congress was aiming to do.
Right. Yeah, I guess the time and place was different and the situations were different when they came up with this rule, but it's no longer kind of, significant or impactful in this, or it doesn't make sense in this. The only thing I can think of is India needs to put a cap on its population maybe to to sort of help with the numbers there. Shouldn't need to, but given we're one of the most populated countries in the world, so that is also definitely causing a factor towards a backlog, I think. But thank you so much for that, Rebecca. Before we move on to our callers and stuff, is there anything else that you'd like to add to this?
Yeah, so along the lines of what could possibly be done to alleviate that backlog. So I believe Rahul has discussed on here before some of the potential bills in Congress that are aimed at alleviating that. One that recently we have been getting questions about, and that was sort of in the news recently, just in the past week or so, is the Meng Amendment, which a lot of our audience may be familiar with. And it's been introduced by this Congressperson, Grace Meng, in the past, where she basically proposes to recapture wasted visas from prior years. Right now, the system, which is also not a great system, is that if green cards are not all used within the fiscal year, they don't roll over into the next year. They just go to waste, which is also contributing to the backlog along with the 7% country cap. So in the past week or so, the House Judiciary Committee did advance the Meng Amendment as part of its DHS appropriations bill. It would still be a long way from actually being put into effect. It still would need to be passed by the full House and then by the Senate, and then potentially through the conference committee, make it through that entire process. So it's by no means, there yet, but it is something that a lot of our audience is aware of, which, if it did go into effect, would help alleviate the backlog for Indian nationals to the extent that that it would recapture the prediction is about 400,000 unused employment-based green cards since the 90s. Yeah.
Recapturing is one thing. What are your thoughts on how quickly can they actually process these numbers, even if they do have the availability,
Yeah, exactly. So one effect that we are seeing as a result of kind of the advocation efforts of the audience of this show and letter writing campaigns, that sort of thing, is that we are seeing USCIS significantly increasing their processing of adjudicating the I-485 applications in the employment-based category. Last year, where there were green cards wasted, they waited too long to really ramp up their efforts until August, September, where it was limited what they could do by then. But it does seem they are putting into effect efforts to try to speed up processing since earlier this year, 2022. And the effects are, we are seeing more application approvals at a faster pace in the past month or so. Okay. So USCIS is implementing measures to make it more efficient to get these applications processed. Their statements have been that they aim to process the eligible employment-based I-485s that were filed by early June 2022. Those are what they're targeting to process by September 30th of this year. And they're saying that their goal is to use up a significant number of the actually 280,000 employment-based green cards that should be available this year. Our hope is that they will, get pretty close to that goal. They do seem to be taking steps toward that, but definitely we have to keep the pressure up. Another thing that they could do that we are not sure that they are doing right now, they haven't announced that they're doing, is basically pre-assigning a visa number to an I-485 application before they get through the whole approval process. Right now, all we know is that they assign a visa number to an I-485 application at the approval point. When it's finally approved, gotten through all the stages, that's when they assign the visa number. That's how it doesn't get wasted. But we have heard some indications from the ombudsman and some other kind of sources that officers have the discretion in some cases to assign a visa number to an I-485 application even when it's not approved yet. And because of that, we've seen some I-485s approved when their priority date doesn't seem to be current, when the dates have retrogressed, for example, and then we inquired about it. And we were told that the officer had the discretion in that case to assign the visa number at the time the priority date was current. So the retrogression didn't affect them. They were still able to approve it. If that's the case, then, one common sense solution to the adjudication problem is to assign the visa numbers en masse to the applications in the pipeline so that if they can't get everything done by September 30th for some reason, those could still be approved potentially after October.
Right.
And our partner, Emily Newman, has a blog, immigrationgirl.com. So she has a sample letter on her blog on that exact topic of encouraging our congresspeople to put pressure on USCIS to use that exact mechanism of assigning the visa number in another effort to prevent the visa wastage.
Got it. So are you saying there's like a letter template that they can send to their congressman?
Yes. On immigrationgirl.com, the blog of Emily Newman, our partner, she has one of her recent blog posts has a template letter along those lines.
Okay. And we'll, folks, we will try to link that template as well in the chat towards the end of the show. So you all can have it. And please make sure you send these letters to your congressman to put some pressure on USCIS, because the benefits are, hey, at least we have a visa number and it doesn't get wasted. So that was an amazing point, Rebecca. So on this note, let's just get started with our callers. Okay, let's take our first caller for today. Caller with phone number ending in 7430. Caller with phone number ending in 7430. We're ready for you now. Hello, please press star 600 to unmute your line. Hello?
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 Yes, sir, please go ahead. We can hear you.
Hi. My 485 was applied with downgrade in October 2020. My priority date is May 2014, but it was downgraded as an amendment. Can I go ahead and file new I-140 with upgraded amendment in premium processing? Does the USCIS will accept as a premium processing?
Yes. So in your case, since your EB3 downgrade was filed as an amendment rather than a new I-140 application, doing that basically converted your existing EB2 approval to an EB3. So right now you don't have an EB2 that you can interfile back to, but if your I-140 petitioner is willing to file another I-140 petition for you in the EB2 category, they can use that same perm. They don't need to go through the perm labor certification process again, but they would just need to submit the I-140 application again for you in the EB2 category, and you would be able to file the I-485 application concurrently with it.
Okay, do I need to file, my second question is, do I need to file new 485 or my existing 485 will be automatically converted to EB2?
That's another option. You can have the current pending I-485 transferred to the new EB2 that's being filed. So in order to do that, it won't be automatically transferred, but you can have the company also send in an I-485J supplement requesting the transfer of the underlying basis from the EB3 to the new EB2 application. Also, when they are sending in that new EB2 I-140 application, they should include a cover sheet that says that basically this I-140 is going to be the basis of a transfer of underlying basis request, an interfile request.
Okay, thank you so much.
Sure.
Thank you, sir. Thank you so much for calling, Andy. Let's take our next caller.
Thank you.
Thank you. Caller with phone number ending in 0594. We ready for you now? Hello?
Hey, Nitya garu, can you hear me?
Yes, we can hear you, Andy. Please go ahead.
Hey, Nitya garu and Rebecca, thanks for taking my call.
Sure.
My question is, my priority date is April 2030, and I have filed downgrade in October 2020. I've got my advanced payroll and EAD card and all that. So recently my case has been transferred from Texas to NBC and then to a field office in Alabama. However, I haven't submitted the medicals and I've received a RFE for medicals and I haven't done an interfile yet. So I was wondering if when I send my medicals, so would they adjudicate my case or do I have to still file the interfile?
Okay, you said your priority date is in 2013, right? So it's current in EB2, but not in EB3.
That's correct, yeah.
Okay, and your company hasn't sent in an interfile request yet?
Yes, that's right.
Yeah, we have heard of a few similar situations. It is a bit odd because when an I-485 file is transferred to a field office and they are asking you for your medical exams, that's usually at the very end stages of the approval process. A lot of times people get the approval shortly after submitting the medical exams. But we have heard of a few other situations like this when medicals are being requested for someone who is not yet current in the EB3 category. And we have actually heard of some people getting the approval in the EB2 category, even though they didn't submit an interfile request. We're not really sure how if USCIS has some sort of policy within their service centers, if they see an EB2 on the record, that they are just moving those for final adjudication, assuming maybe that it will be interfiled. But I would say in your particular case, if your company is willing to do the interfile to EB2, I would go ahead and send it in along with the medical exams to the field office in response to the RFE. I would also file it. Both? Yeah, I would also file it with the Western Forum Center, which is where they instruct the J supplements to be sent. But I would include a copy also in the RFE response.
So should I include both the letter and along with the 485J along with my medical?
Yes, you can include a cover letter kind of confirming that basically the J supplement is being submitted to you to request that the transfer of underlying basis from EB3 to EB2, and that a copy has also been sent to the Western Form Center. Since if the RFE is only asking about medical exams and you're sending the medical plus something else that they didn't ask for, it is probably helpful to include a cover letter explaining why you are sending in the J supplement.
Okay, got it. And one more question. So my wife's advance payroll, so they only shoot for like 1 year. So when can I submit for a renewal?
Up to 6 months before it expires. So up to 180 days before the current expiration, you can file for the renewal.
Okay, cool. And do you suggest to like do a refile?
Let's try to give the others a turn as well, sir. We usually limit it to 2 questions per person. Sorry about that, and thank you so much for calling in. Let's take our next caller, and in the meantime, Rebecca, there's a question for you. This is from Sirisha CH. She says, spouse's H4 extension not approved yet. Planning to go to Mexico for AVR to get EAD auto extension. As H1, H4 visas expired in passport, do we need Mexico visitor visa?
Yeah, that is a good question. So I would say that up until a couple months ago, for the most part, we would say no, because automatic revalidation has been, available for many years, and the whole premise of the automatic revalidation is you have an expired U.S. visa and you're going to return with the I-797 approval notice with the I-94. And for the most part, in the past, Mexican immigration did not require you to have a visitor visa to enter Mexico. We have heard reports of more people, not all, but more instances in the past couple months of immigration officials in Mexico either still admitting people in some cases, but telling them next time you come, make sure you have a visitor visa to Mexico, or a couple cases where they were denied entry into Mexico because they did not have a Mexican visitor visa. It's still not the majority of cases that we hear about, but it does seem to be, the frequency of those seems to be increasing from what we're hearing. We don't know if maybe it is because, definitely the amount of travel to Mexico kind of for the purpose of automatic revalidation in the I-94 extension has increased this year since the H4 auto extension policy came in, and people are, doing what Rahul calls the margarita switch to, extend the I-94 without waiting on the I-539 by just going to Mexico or Cancun for the weekend. So it may be that that increase in travelers coming in for that exact situation, maybe Mexican immigration on their side is starting to say, in the past we've allowed it, but we're starting to, move towards requiring the visitor visa now. So in general, I have been recommending now that if you have time it's safer to get the Mexican visitor visa. But depending on when the H4 spouse's I-94 expires, because you want to make sure you're traveling and coming back before that I-94 expires, if you don't have time to get the Mexican visitor visa and are aware that there's a possibility you may not be admitted into Mexico and you still want to try it, you can still try it. We are still hearing of people having success doing that. The worst case scenario, if they don't let you into Mexico, you would still be admitted back into the US. So automatic revalidation would still work for you to come back into the U.S. You just may lose, the value of the hotel booking or whatever you had booked in Mexico.
Okay, I don't think that's such a big risk for people to take. So that's awesome, Andy. Thank you so much. Let's take our next caller.
To be admitted back into the U.S.
Caller with phone number ending in 5888. Are we ready for you now? Hello? Hello? Caller with phone number ending in 5888. Caller with phone number ending in 5888. We're ready for you now. Please press *6 to unmute your line. Hello?
Yeah, hi. Can you hear me?
Yes, sir, we can hear you. Please go ahead.
Okay, all right. Hello, Rebecca and Nitya garu. I have a question. I'm going to India on a GC, and my wife will be staying more than 6 months. So will that affect anything in terms of taxes or in terms of getting citizenship or while coming back? If you can share some light, that would be helpful.
Yeah, so congratulations on getting the green card. So one thing you do need to keep in mind when you've gotten the green card, it's, technically it's called the permanent residence card. And so one of the main requirements, you don't have any requirements anymore of where or for who you work or anything like that. But USCIS or the government does want to see that you are making your residence in the U.S. So if it ever looks like to them that you are actually living elsewhere and just coming into the U.S. Briefly, there is the possibility they could revoke your green card, sometimes just at the border, if you're not expecting it. In general, a stay of 6 months or less won't be any problem. Anything more than 1 year, there's definitely a presumption by border officials when you're coming back that you have abandoned your U.S. residence, and so that could be a problem. Between 6 months and 1 year, it's more of a gray area. You may be questioned about kind of why you stayed outside for several months, and questions about sort of whether your residence is still in the U.S. When you are coming back. But if you have, or your wife has documents, confirming that her residence is still here in the U.S., things like, the lease or deed for your property, insurance policies, bank statements for accounts that she still has here, that sort of thing. As long as she's prepared with those documents and prepared for potentially, a longer interview when re-entering the U.S., then I would say a stay of 6 months to 1 year should be okay. If you want to be absolutely safe, you can apply for a re-entry permit. So that's the form I-131. It's the same application you use to apply for advanced parole. But you can apply for a re-entry permit. That basically is a declaration that you intend to preserve your U.S. residence. The main thing with the re-entry permit is you have to apply for it while you are still here in the U.S. So she would need to apply for it while she's still here in the U.S. and stay long enough to give the biometrics attached to that. And it could still take about 6 to 8 months to process, and then it can be, you can request it to be mailed abroad or, sent to someone here in the U.S. who will mail it to her. That is another option. If it seems like it might get closer to 1 year, that might be something to consider if you have time to apply for the re-entry permit.
Okay. Rebecca, actually it is 6 months, 10 days. That's what my wife is planning. But I'm going to come back in a month or so. The primary applicant who got the GC, I'm going to come back in a month, but my spouse is going to stay for 6 months, 10 days.
Yeah, I think that won't be a problem at all. I would say you probably don't need to apply for the re-entry permit for her in that situation. That should be fine, although I would still recommend having the documents prepared in case she is questioned. Something else that she could bring is, documents to show that, like your recent pay stubs maybe in the U.S. to show that you have been in the U.S. and that you're still working here, to show that, obviously, her family is still here in the U.S. That could be another thing to show her ties.
Or do you recommend coming back in less than 6 months or 5 months or something like that? We had a new baby, so I wanted to.
I would say just barely over 6 months is probably still fine. 5 months will always be safer. Anything less than 6 months will be safer, although I wouldn't say that 6 months, 10 days will really be an issue. I would just recommend to anything over 6 months to just be prepared with the documents. She may not even be asked if it's just barely over 6 months, but just be prepared.
And Rebecca, correct me if I'm wrong, you said that the applicant for that I-131, the re-entry permit, has to be in the country when they're filing the application, right? They do not need to be in the country, till it's approved, correct?
That's right. Yeah, because waiting for it to get approved could take, several months. You just need to be in the U.S. at the time it's received by the government, by USCIS, And we usually recommend staying long enough to give the fingerprints, which should be within a month or so after filing.
So, sir, it sounds like you can just file in the application and then leave, at least to be on the safer side. So, you know, at least that way you can say that we already filed a re-entry permit when you're coming back in case asked, you know?
Yeah, that is definitely an option too.
All right, so thank you so much for calling in, Adi. We'll take our next caller for the day.
Sure. Yeah. Bye-bye.
All right, caller with phone number ending in 0505. We're ready for you now. Caller with phone number ending in 0505. Hello? Hello? Caller with phone number ending in 0505. Hello? Okay, let's try to put this caller on hold and we'll take another one. And we'll revisit this caller, please. Caller with phone number ending in 8222. We're ready for you.
Hi.
Hello, sir. Sir, can you please mute your TV line and then press *6 to unmute your phone? Caller with phone number ending in 8222. Please press *6 to unmute your line. Hello? All right, I think we're having some issue. All right, let's take another caller. In the meantime, let's do a question. This is from Kishore C. It says, I-485 filed an EB3 in 2020. July 1st, a new 485 has been filed based on EB2. Planning to interfile end of July. How will USCIS process the adjustment of status if we do interfile and refile same time?
Yeah, USCIS can still process both. Usually if you hadn't filed the new I-485 recently, we would normally recommend interfiling over refiling because the effect of having filed the new I-485 in EB2 and then later interfiling, it just means you'll have two I-485s now, both in the EB2 category. And, just whichever one gets approved first, but it's more likely that the application filed in 2020 will be approved first if USCIS gets the interfile request kind of scanned in and matched up to the file quickly enough. I would actually recommend, if you've already gone ahead and sent in a new I-485 in the EB2 category, that's fine. It won't hurt anything necessarily. It just may not have been as necessary. I would actually recommend sending in the interfile request as soon as possible. I wouldn't really wait until the end of July. Because like we said earlier, the group of applications that USCIS is targeting to adjudicate by September 30th are I-485s that were filed by early June 2022 that are eligible to be approved. So right now, the caller's 2020 I-485 was, filed early enough. The only thing to make it eligible right now is getting it into the EB2 category, which you can do by interfiling. So I would try to get it interfiled as soon as possible so that then it's in that group that USCIS could potentially target to approve by the end of September.
Thank you. Let's take our next caller, Andy. All right, caller with phone number ending in 5582. We're ready for you. Caller with number ending in 5582. Hello?
Yeah, hi.
Hello, sir. We can hear you.
Hello.
Please go ahead.
Yeah, can you hear me?
Yeah, we can hear you.
Okay. Hey, good afternoon, ma'am. So I have a question like my priority date is October 2012 and I did downgrade from October 2020. Now I got a medical RFE and my case got transferred to a field office for myself only, and my wife and my kids' case is still pending in Texas. So do I need to do anything for them?
did you send in an interfile request to move your case to the EB2 category?
No, I didn't do that. In fact, I was in current for like in EB3 for like almost 3 months when it was current in 20 like last year. So I didn't interfile because we used our advanced parole to come back to US. So I cannot do interfile.
Have you changed employers from your I-140 petitioner, or are you still working for your I-140 petitioner?
The same petitioner I'm there, but what my attorney is saying, since I use the AP, so my I-94 is not like an immigrant I-94, so I cannot use that current I-94 to interfile. So
actually,
if I want to interfile, I have to,
To interfile, it's not necessary to be in H-1B or H-4 status. It is if you want to file a whole new set of I-485s in the EB2 category to basically refile, you do need to be in, H status. But to interfile, you're not filing a new I-485, you're just asking USCIS to move your existing I-485 from the EB3 category to the EB2 category. And if you're
sorry, I forgot to mention, like I did an amendment during the downgrade. Okay. I don't have a 480.
I-142.
I don't have a 4.
Okay.
Correct.
Yeah, so it is still possible to interfile, but your situation would be a bit similar to our very first caller, where the I-140 petitioner would need to file a new EB2 application for you, which they can. They don't need to go through the labor process. So I would say, in your case, I would encourage you to try that if possible, because even though yours has been transferred to the field office or the NBC, your priority date isn't current in EB3, and your current I-485, since there hasn't been an interfile request yet, your case is only in EB3 and your priority date is not current in EB3. So I'm not actually sure why they have transferred it to the National Benefits Center. Like I said earlier, we are hearing of more cases like this where it seems like people whose priority dates are not current, who may have had a prior EB2 priority date that was current, but currently their pending case is only in EB3. It hasn't been interfiled. We are hearing of more cases like that being transferred to the National Benefits Center, and we don't know if it's a case of USCIS kind of getting ahead of themselves. Maybe they're anticipating that it will be interfiled. But I would say that since your case, according to the current guidelines that USCIS has said, your case really shouldn't have been moved to the National Benefits Center yet. I don't think there's anything you can really ask USCIS to move your family's cases to the National Benefits Center also. All that might happen is that they might realize that yours was moved to the National Benefits Center before it should have been, and they might transfer it back. So I would actually lean towards, if your I-140 petitioner is willing to file another I-140 for you in the EB2 category, if they're concerned about the fees, technically they are not required to handle the I-140 filing fee. It can be paid for by the employee if that will help in kind of your discussions with them. But if they're willing to file that on your behalf, then I would encourage that and to send in the interfile request. That then may kind of get USCIS looking at your file again and realize, okay, your file's already been moved, and then they might then move your family's cases to the National Benefits Center also.
Okay, got it. Yeah, I'll talk to my attorney. Let me see what she's saying.
Okay.
Thank you.
You're welcome.
Sir. Thank you so much for calling, Andy. All right. Let's take our next caller, please. Yeah, thank you. Caller with phone number ending in 2259. We're ready for you now. Caller with phone number ending in 2259. Hello? Please press *6 to unmute your line. Caller with phone number ending in 2259. Hello?
Hi, Nitya and Rebecca.
Hello, sir. Go ahead, sir. We can hear you.
My daughter is converting from F1 to H4 to F1. Is it compulsory to pay civics fees or not? But administrative counselor is telling civic fees is not required if you stay in same university. That's what administrative counselor told.
Oh, I am not 100% sure on that, actually. That may be the case, that if you're not transferring universities, if she has already started at that university in H4 status and will be continuing in that university in F1 status, the service fees may not be necessary, but I'm not 100% sure on that, actually. I would probably go by what the DSO says, because they are more familiar with kind of the service system and what is usually required from that.
Okay, okay. And what all documents is required for stamping from H4 to F1, DS 160, and then this I-2 financial documents? That's any other documents required?
So actually, for H4 children who are thinking of moving over to F1, we normally recommend going the I-539 change of status application route rather than the visa stamping at the consulate route, for the reason that the F1 visa is still a visa that requires you to have the temporary intention only to stay in the U.S. And part of that analysis that the consular officer makes is whether the applicant has sufficient ties to their home country. For children in H4 status who have grown up primarily in the U.S., whose parents are in the U.S., who all their ties are primarily in the U.S., it can be difficult to show sufficient ties to India if they're applying for the F1 visa at the consulate. So if that's the case for your daughter, we would usually recommend applying for the I-539 change of status. We have heard of people successfully, teenage H4 children moving to F1 by going through the consulate, but because there is always that risk of the consular officer going into the ties to the home country, if the officer does, that could be difficult to overcome. So if it's possible, if there's enough time, we usually recommend filing the I-539 here in the U.S.
Yeah, last question. How many days it will take if we want to convert from F4 to F1 staying in US itself?
Yeah, the downside is that process could take several months. I would say at least 8 to 10 months is pretty common. It does seem like USCIS is prioritizing cutting down on the processing times of their I-539s. They have stated that they're aiming to get it down to closer to 6 months, but it could still take longer than that. The main thing as far as the timeline that you need to make sure of is that the I-539 application needs to be filed before your daughter turns 21. Technically, as long as that I-539 application is filed while she's still in valid H4 status before she turns 21, she'll be in a period of authorized stay after she turns 21 if that I-539 application still takes another 10 months or so to process. But if you can get it filed earlier, we normally recommend that people start around age 19 if possible. If you can get it filed earlier, that's always recommended. But technically, even if it's filed at any time before her 21st birthday, she can still remain in the U.S. in authorized stay while it is processing.
Okay, thank you. There is no premium processing, right?
Yeah, unfortunately, there's no premium processing right now for that I-539 application.
Okay, okay. Thank you very much, Rebecca and Nithya.
Thank you, sir. Thank you so much for calling, Andy. Let's take our next caller. All right, caller with phone number ending in 7728. We're ready for you now. 7728. Hello?
Hi, Nitya. Hi,
Hello, sir.
How are you? Yeah, can you hear me?
Sir. Yeah, we can hear you, sir. Please go ahead.
Yeah. So about my case, I'm an EB2 September 2014, and my case is in Texas. I interfiled recently, and the status changed to initial review. I haven't sent my medicals yet, waiting on RFE. My question is that my wife's status has not changed. My question is that I need to travel to India for a couple of months. So I have done the medicals and kept the files ready, copy with me and copy with my attorney. What else do?
Hello?
Yeah.
Sir, can you continue? We lost your audio for a minute.
Okay. Okay. So my priority date is current since June. I interfiled. My file is in Texas, and it is the status changed to initial review. I'm waiting for medical RFE to submit my medicals. My medicals files are ready with me and my attorney. I need to travel to India for a couple of months. So what do I need to do? What do I need to take care of during the travel, or anything I need to worry about?
No, not really. Do you have the advanced parole card?
Yeah, I have my EAD and AP valid till next year.
Okay. And you'll be using it to come back instead of
Yes.
H-1B visa? Okay. Yeah, that's fine. As long as your advanced parole is valid, you can travel internationally while the I-485 is pending. Yeah, that's a good move to have the medical exams ready and with your attorney before you leave the country, so that if you get the RFE while you are outside the U.S., your attorney can submit the exam on your behalf. You don't have to be in the U.S. in order to have that RFE responded to. And technically, you don't need to be in the U.S. for the I-485 to be approved. So there are cases where the applicant is outside the U.S. at the time the I-485 is approved. And if that happens, just have your family or your attorney keep an eye on the case status. And if it does move to approved, just be aware that when you're coming back into the U.S., you'll be coming back as a permanent resident. Basically, once the I-485 is approved, the advanced parole, any H-1B or H-4 status is kind of automatically invalid. So you'll be coming back as a green card holder. Either they can have the green card mailed to you to where you are abroad, if they are, if there's reliable way to get it to you. Otherwise, you can carry the I-485 approval notice, and usually they can look that up in the system when you're at the border. But that's about it. Yeah, I don't think you have to prepare anything else at this time. If you want to, Rahul has recommended in the past that if you know that your medical exams have not yet been submitted, Rahul has advocated for just going ahead and sending in a medical exam if you have an extra one, and just give it a try, without having received an RFE. USCIS on their website, they have said that they don't want people to send in unsolicited medical exams because they have difficulty matching it up to the file, which is true. There's, if you are going to send it in independently on your own, be aware that it may not get matched up to the file, but it sounds like you have an extra copy, which is also a good move. So if you want to go ahead and try that, that may be worth a shot. And then if the RFE comes anyway, you can have your attorney submit it.
Yeah, my status changed to initial review, Rebecca. So that is why I was thinking I might get an RFE soon. That's why I did not submit it.
Yeah, that's a possibility too. Mm-hmm.
Okay, and I did it in first week of June, the medicals. Do I have to submit within 60 days or is that okay?
Yeah, actually the 60-day requirement is suspended right now. Any medical exams submitted by September 30th of this year, they can be more than 60 days old and USCIS will accept them.
Okay. Thank you so much.
Thank you, sir. Thank you so much for calling, Andy. All right. Before we take our next caller, I have a question for you, Rebecca. This is from Supraja R. Says, we filed EB2 in November of 2012 for GC, downgraded to EB3 later as dates moved again. We upgraded back to EB2. The receipt for EB2 received just 2 days later, EAD received. USCIS says it won't issue a new EAD on EB2.
Oh. We haven't heard of that as far as I know. So I assume that the that the person asking the question submitted a new set of I-485s in the EB2 category rather than interfiling. So if you have submitted a whole new set of I-485s in the EB2 category, you are eligible to apply for another EAD card attached to that new I-485 application. And we have heard people who have refiled who end up getting 2 EADs if they, sent the I-765 for both applications, and you're entitled to receive 2 basically, since each one you submitted a whole filing fee for each I-485 application.
Right.
Yeah, that is a new one. I guess on USCIS side, they are, I don't know if this is their way of trying to make things more efficient for them. If they are basically saying that we see that you already got an EAD related to your EB3 I-485, you can use that one. I don't know that they're really allowed to do that because technically you are entitled to a new one if you submitted an I-765 with your new I-485. Yeah, actually, if you do,
they should have an option of being able to choose, right? Like which EAD.
Yeah, definitely. Mm-hmm.
Yeah.
Yeah, because sometimes the EAD that you use will attach you to that I-485 to the EB2 or the EB3, so it could have an impact.
Rebecca, do you recommend that they get in touch with a lawyer for this, or how do you think they should work this?
Yeah, this may be something that you can see if a lawyer can file a motion to reopen potentially, since it is, I would say that it's due to service error. There is a provision that if you file a motion to reopen, if it is due to if the denial was due to service error, you don't need to submit the filing fee for the motion to reopen. I would say you could give that a try and see if USCIS will, maybe it will get to a supervisor who will, look into it and process it correctly. The other option would be to just file another I-765 based on the pending EB2 I-485. The good news is that there isn't a filing fee required for the I-765 when it's filed based on the I-485, so it doesn't cost you anything to just refile it. It just may, take longer than it should to be issued because a new I-765 will basically restart the processing time on that EAD.
Awesome. Thank you, Rebecca. Let's take our caller, Andy. Caller with phone number ending in 3621. 3621. We ready for you now? Hello? Please press *6 to unmute your line, Andy. Caller with phone number ending in 3621. Hello?
Yes, ma'am. I can hear you now. Can you hear me, Nitya?
Yes, so we can hear you now. So please go ahead.
Sure. Thank you very much. So, Rebecca, hi, Rebecca. This is AJ. Last Friday, we have submitted our adjustment of status application, but after sending the package to the department, my attorney has sent me the scanned copy of whole my package and as well as my wife's package, and I've realized my birth certificate is actually issued in the last 20 years ago after my first year of birth, So along with that, I know we have to submit my affidavit, 2 affidavits from my family or friends, and I've given that to them. So in the package, I don't see those affidavits have been sent to the USCIS. So now, what are the options I have? Just sit tight and wait for the RFE, or is there any exception cases to the C? I just want to know your thoughts on this.
So just to clarify, the document that was sent in as evidence of your birth, was it a non-availability certificate?
No, actually it was like birth certificate, caste certificate, which I got like in 2000, and I was born in 1985. So I've given 3 documents, my birth certificate and the 2 affidavits, but I see in the package they only sent my birth certificate. So, is that an issue?
It may not be an issue. I would say as long as it was a certificate issued by the relevant government authority in India that was authorized to provide that document, and as long as your name and date of birth are correct on there and it's clear the place of birth, it doesn't necessarily need to have been issued at the time that you were born. So as long as it's an official government record and all the information on it is accurate and clear, that may be sufficient. I would say USCIS may not send an RFE asking for anything additional for your birth. So that may have been why the attorney left out the affidavits, because they felt it wasn't necessary. So I would say it's probably not necessary for you to proactively send in the affidavits. As I mentioned before, when there isn't an RFE, there isn't really a good way to make sure anyway that anything else that you send in independently will get matched up to the file. So I would maybe just hold on to the affidavits. If there is an RFE, you can have them ready to provide, but I would say there's a good chance there probably won't be an RFE actually for your birth documents.
That sounds good. Thank you very much, Rebecca. Appreciate your time and thanks for the service.
Thank you so much.
Thanks, ma'am.
All right, let's take our next caller. Ready? Caller with phone number ending in 7267. You ready for you now? Caller with number ending in 7267. Hello?
Hello? Hello?
Hello, sir. We can hear you. Please go ahead.
Are you able to hear me? Yeah, hi. So my wife has H4 approval till 2023 June, but when she's returning back to USA, she used her advanced parole, so her I-94 was adjusted back to November 2022 as per her advanced parole. So recently when we went for automatic revalidation at Mexico border, the CBP officer refused to adjust her I-94 as per her H4 since we still have the valid I-94. So what are our options to have the I-94 as per her H4 approval?
So when you were coming back from Mexico with automatic revalidation, did your wife have an I-797 approval notice in her name for the H4 with the I-94 attached at the bottom?
Yes, ma'am.
Okay. Yeah, that is a little unusual.
So
we are hearing more cases of CBP along the border sometimes not issuing I-94s or I-94 extensions. We know for the auto extension purpose, they are not as frequently extending H4 I-94s, when they're traveling back with the H-1B spouse. But in your situation, that's not really that scenario. If your wife was coming back with an H4 approval notice in her own name that had a June 2023 end date for the H4 with the I-94 card attached, she should have been given an I-94 valid until June 2023 in H4 status. I would say did you by chance come across a land border, like by car, or were you flying?
Right, so by land border, so one CBP officer extended my I-94, but another CBP officer refused to do her. So we went by land and we stayed there for a day, and then when we are coming back, that time they refused to extend the I-94.
Yeah, for some reason we've heard problems more frequently with CBP officers at land border crossings. For whatever reason, that seems to be more of an issue. I would say what you can try doing is contacting CBP Deferred Inspection to see if they will correct it and update your wife's I-94 without her having to travel again. So there is a way that there are some deferred inspection sites that you can go into in person, but there are several deferred inspection sites that also take email requests for correction, and you're not required to actually contact the deferred inspection site of the exact port of entry that you came through. So you could, if you came in, through one port of entry, you could request deferred inspection by email from a completely different port of entry if you want. So I would try that first, emailing CBP Deferred Inspection, explaining the situation and seeing if they will update it without the need for another trip.
Got it, ma'am. Sure, definitely. One more question is, I refilled my GC application in EB2 category 2 weeks ago, and the status shows as fingerprints taken, maybe from my previous EB3 visa application. But if I cross the border now, will my 485 application in EB2 category will be abandoned?
Are you currently in H-1B status?
Right, ma'am. So they automatically revalidated my H1, so I came back into H1B visa status.
Okay. Yeah, so if you are departing the U.S. while you're in valid H status and coming back in valid H status, your I-485 will not be considered abandoned. So if you are traveling and coming back in through automatic revalidation again, that should be fine. If you are traveling somewhere other than Mexico or Canada, then you would need to get the H-1B visa stamp renewed before coming back in. But if you're able to do that and you're coming back in H-1B status, then your I-485 won't be considered abandoned. That's how to, preserve the I-485 from abandonment if you have not yet received the advance parole. If you have received the advance parole associated with that I-485, you can use that advance parole to travel without getting the H-1B visa stamp.
Okay. I have advanced parole in EB3 category, different category. So that will, I think, affect my... Okay.
Yeah, it's a little unclear on whether you can use the advance parole from the EB3 to come back in and keep the EB2 I-485 going. To be on the safe side, I would recommend that if you are trying to keep the EB2 I-485 alive and keeping it from being abandoned, I would recommend coming back in H-1B status only until you get the new advance parole card.
Okay, got it, ma'am. Sure, definitely. Thank you so much for answering my question.
Thank you so much for calling, Andy. All right. Let's take our next caller. And in the meantime, question for you, Rebecca. This is from, I'm sorry. This is from Raghu Tukral. Says priority date is Feb 14, EB2, filed in May. Now got another job in the same company at a higher level. What are my options? A slightly different title. Job description matches about 60 to 70%. Biometrics have been updated in the case.
Yeah, so if the job is essentially in the same occupation category, then a promotion kind of in the same type of role is fine. It shouldn't require a new perm. It mostly sort of depends on the comfort level of the company. If the company is fine with, if perm and I-140 were approved as a software developer and you're being promoted now into like a lead role or a senior software developer role, that's just a higher level version of that same occupation. That's fine. If you're being moved into a more managerial role, that could require a different occupation code, that's more of a gray area and does sort of depend on the company's comfort level. We know that some larger corporations, if you are being moved into a managerial role, they're no longer comfortable saying that that your role is essentially still a software developer, for example. If that's the case, then theoretically that might require a new perm. I believe in your case, you said that the interfile was done maybe in earlier this year. So if your I-485 has been pending for more than 180 days, then you may be able to use AC-21 actually. So AC-21, usually we talk about it as, allowing you to move employers, move to a completely new company after the I-485 has been pending 180 days. It also enables you to move into a different role within the same company or a different location with the same employer, as long as it is same or similar. So that is, if your I-485 has been pending at least 180 days, you could take a look at that with your company and see if that could cover this promotion as well.
Awesome, thank you. Let's take our next caller. Caller with phone number ending in 0766. 0766. We ready for you now? Caller with phone number ending in 0766. Hello? Hello?
Hi, Nitya. Hi, Betty.
Hi, ma'am.
Hi. Can you hear me?
Yes, we can hear you. Please go ahead.
I have two. Yeah, thank you. I have two questions. My first question is, my son is outside of US and we filed his I-130 in F2A category. And ever since he's out, we would like to know if we can get his I-130 expedited for consular processing. If this is an option?
I'm not aware of really any expedite options on the I-130 side or the family-based consular processing side. There isn't a premium processing option right now for the I-130 application. So I know that is taking sometimes close to a year to process just the I-130. And then the process through the consulate, I know, is also taking quite a long time because consulates have been they're still catching up from the backlogs they experienced during the pandemic when they shut down a lot of operations or had very limited services. On the family-based side, they're still catching up quite a bit on cases that were pending, during 2020 and 2021. So unless there's some kind of very serious sort of humanitarian situation where it's essentially a life or death situation, I would say there aren't that many expedite options available. If it is a very extreme emergency situation like that, you may be able to reach out to your local congressperson and through their liaison's office, have them reach out to USCIS and the Department of State, which oversees the consulates, to see if anything can be done. But usually it has to be a pretty extreme situation in order to get that expedited.
Okay, because what is happening now, he is outside and he really cannot come to US to visit us, right? Because we are permanent resident and he cannot use B1, B2 visa also to come to US because his 130 is in processing, so it's kind of stuck. And he really wants to come to US to meet us because he just turned 21. He's really missing us. So is there any way he can come to US just for visit purpose?
Not as far as a visitor visa, from what I'm aware of, since, as you mentioned, now that he's in the green card process, he won't really be able to travel anymore on a B1, B2 visa. Even if he already had one issued to him, CBP won't really admit him now that he has a green card process on the record and in process. Really, the only other thing that I can think of that might allow him to come in before that is the H and L visas are dual intent visas. Those are really the only types of visas that allow you specifically to have the green card process ongoing, and you can come into the US on these temporary H or L visas, but those are work visas. So it would basically require him to have sponsorship from a company to come in for a job offer. But as far as just a straight visitor visa, unfortunately, I don't think there are that many options until the family-based process is complete.
He's still studying, so definitely he will not get any job offers.
Unfortunately,
okay, so we have to,
Sorry, ma'am.
Okay, so only option is to wait for the AC to be processed. Thank you, Becky and Nitya, for taking my question.
Thank you so much for calling. Sorry, and all the best, Randy. Hopefully you'll get, some good news soon. Thank you so much for calling. All right. And folks, I know we have a lot of people waiting on the live chat as well as the call log here, but unfortunately we're all out of time today. Rebecca, I wanted to take this opportunity to thank you so much for being on this show and for, answering as many questions as was brought up today.
Thank you for having me.
And to all our viewers, I think we'll be back same time, same place next week with another expert for our immigration related questions. So stay tuned, don't go anywhere, and have a great week, and we'll see you next week. Thank you.
Test Prep Pundits, a synonym for success, and a home to top 1% scores. Congratulations to 𝐂𝐓𝐓𝐻𝐸 for achieving SAT score 1570, Farah Khalil 1540, Kunal Varma 1510, and many more top 1% scores.
Join our summer premiere SAT and ACT program. Pay now. Start in summer and get 40% discount.
Contact us, info@testpreppundits.com, or call us 844-383-7844. Visit us, www.testpreppundits.com.
మలబార్ గోల్డ్ అండ్ డైమండ్స్ వారి గోల్డ్ ప్రామిస్ తో కురుస్తోంది బంగారు నాణాల వర్షం. గోల్డ్ అండ్ డైమండ్ ఆభరణాలు కొనుగోలు చేసి బంగారు నాణాలని ఉచితంగా తప్పకుండా పొందండి. త్వరపడండి, మీ దగ్గరలోని స్టోర్ కి వెళ్లి ప్రత్యేకమైన జ్యువెలరీ కలెక్షన్ ని ప్రత్యేకమైన ధరల్లో పొందండి. కేవలం మలబార్ గోల్డ్ అండ్ డైమండ్స్ తో మాత్రమే.
Malabar Gold and Diamonds.
Hire international teachers who are well trained in U.S. curriculum for just $20 an hour, or for 2 students group, $15 an hour. We teach math, science, and English for elementary, middle, and high school. Contact info@testpreppundits. Call at 844-383-7844.
PSAT. Do you have a middle school child? Are you aiming for top Ivy League colleges? Do you know how strong they are in academics? We have an innovative PSAT program for grades 6 through 9. We will help your child thrive in academics and get them to the top 1% of the nation. It's never too early to start. Join our prestigious PSAT program. For more information, contact us. info@testpreppundits.com or 844